Hello. How is everyone doing? It's a Monday. I hope everyone's feeling all right. It's we got a whole bunch of things to cover, and one of them is 266 pages long. We are not going to go through the whole thing. Oh, and I'm being told I forgot to say boom. So, boom. Um, so we have a bunch of things I want to cover. The first one on the agenda, because there's a whole bunch of people who I think will be here just to see this, is the decision in the case of, well, a whole lot of people versus the government, basically. And so it's going to be an interesting case. People have said, is this over? Is it done? I think there's going to be an appeal, but we'll see. Now, I am not. Oh, and I'm seeing. I like how you have the Roll of Law logo in the corner. I am not supposed to. I'm going to magically poof. There we go. So we got that switched over there to the correct logo, because correct logo is the thing to have. So we are, we're gonna talk about this one briefly. And when I say briefly, I'm going to go through this one in a lot of detail later. At some point later, I'm going to go through this and try to do a very deep dive on this one. Now, I'm going to have trouble with the deep dive on this one because it is 266 pages long. And I can tell you, if I'm covering everything in it, nobody's going to want to watch, because if I want to do a video that is however many hours long, a lot of people will tune out. So I'm going to have a lot of work going through this and, basically trying to boil it down to the critical elements and the critical discussion. But so the first thing I guess people are going to want to know is, what are you talking about, Runkle? Because I think some of the people here will have no clue what I'm talking about. And that is the latest decision of the federal court. And so we're just going to pull this up onto the screen here. And boom. There we go. So this is the decision of the Honorable Madam Justice Kane. Now, some people have been very upset with her personally. I'm going to say don't do that, because I don't think that there's anything. I don't think that there's any reason to go after her personally on this one, but sometimes people get upset and want to do stupid things. So this is she's just a judicial official. It's just part of the process. And I'm going to say this is this was a long shot at the outset. Oh, Dragon's Angel, the tie is being cleaned. I got to get the tie back up on. I think it's actually done being cleaned, and I think it's in a bag, but I've got to get it back up on the door. So sorry, don't read too much into the tie being missing. We'll get the tie back up here. So Cassandra Parker and KKS Tactical Supplies and the Attorney General and Attorney General of Alberta. The CCFR, that is a Canadian firearms rights group. Rodney Giltaca, Maccabee Defense, and Wolverine Supplies. This is another group. John Peter Hipwell, that's another group. I think Ed Burlew was the counsel for Hipwell. So this is the sort of Burlew group here. And then you've got Doherty and various others. And you've got Christine Genereux, John Perocchio, and Vincent Perocchio. They were self-represented. Ms. Genereux was leading the charge on that one. And I'm going to note some people on Twitter have treated Ms. Genereux poorly. And she was doing the best she could as a self-rep, and she did pretty good for a self-rep. But yeah. So Montreal Firearms Recreation Center, or, this is sort of described in the decision as the Eichenberg Group. So all of these different groups essentially were suing the government. And what are they suing the government for? Well, they wanted a declaration that the Order in Council banning the AR-15 in Canada, as well as a whole host of different other guns, was unconstitutional or illegal, or there were various arguments made as to why this order in council should be thrown out. So that is what they were going to do. That is what they were off to challenge, and they were not successful. And I say, unfortunately, they were not successful because I own guns that were affected by this, and I think lots of people do as well. Probably more people do than think they do, because, for instance, this also bans like 8-gauge shotguns, which, I mean, aren't super common, but 8-gauge shotguns are not, are kind of just hunting shotguns. So Murray Macbeth, if it's blurry for you, check your settings. You may have it set to a low resolution, so you may want to turn that up. All right. So let's sort of, I guess we'll start out by just talking about what the conclusion is, the overall ending. So the conclusion, the result of this application, is that they are dismissing the applications. They're throwing out the challenge to the government. So the government wins. And they say the order in council and the regulation are not ultra vires. Now, ultra vires, that's a term for when the government uses power it doesn't have. So the usual place where you get a decision that something is ultra vires is when you've got the federal government passing laws in areas that are provincial powers, or the provincial government passing laws in areas that are federal. So, for example, let's say you've got a provincial government that tries to pass a law for criminal purposes. They're basically trying to make something a crime. Well, the provinces don't have that power. That power belongs to the federal government. And so that would be a law that would be ultra vires. That's what that means here. So they say the governor and council did not exceed the statutory grant of authority delegated to it by Parliament pursuant to subsection 117, 115 of the Criminal Code. So they also note the government formed the opinion that the prescribed firearms are not reasonable for use in hunting and sport, and the opinion and decision to prescribe the firearms as prohibited are reasonable. So let's talk a little bit about what this means. So Section 117.15 of the Criminal Code requires that where the government is going to ban a firearm via order in council, they can only do so if they are of the opinion that these are not suitable for use in hunting and sport shooting. Now, keep in mind, there were a lot of people who thought that this was a big restriction on government power, and none of those people were sensible, because the government can form an opinion on basically very flimsy ground. The government can just kind of decide that this is the case, and they have to be reasonable, but reasonable is the standards of reasonable for the government are basically, you could put it as like not crazy and not actively malicious. And they're going to be really reluctant to find that the government was either crazy or malicious. So long as they can point to some basis to draw this conclusion, they were likely to find this reasonable. That isn't to say that it isn't worth challenging and worth arguing this issue, but I always thought that this was a bit of a long shot. And I mean, this is the way constitutional litigation goes. You take the shots that you think you can, right? You argue the issues you think might have a hope of success. And I would have loved to see this win. I think it ought to have won, but that isn't the standard for how it, for how this goes. Now, one of the things is the courts in recent years have been incredibly deferential to government power. There's a case of called Vavilov, And Vavilov, as a decision, like as a court decision, essentially says that reasonability is going to be presumed on the part of the government and that it's going to be a wide range. It's going to be hard to shake decisions that are based on reasonable. So that is kind of what we're looking at here. Now, they also note the Governor and Council did not subdelegate its statutory grant of authority to prescribe firearms as prohibited. I'm going to try to explain what this argument is. So governments have power, but they're not allowed to give that power away to other people. They're required to exercise that power themselves. And so, for example, the federal government couldn't say, could not, for instance, declare that Runkle gets to make criminal law, even though I'd be good at it. Like, even though I would be excellent at deciding what things should and shouldn't be crimes, they don't get to just give that power away. And so the argument that was being made here is that because the Specialized Firearms Support Service, the RCMP, would make their opinions of classifying firearms, that was effectively banning it. And so effectively this argument is that is giving that power away to the RCMP and essentially giving them criminal law power. Now, I should note, police making criminal law and police making laws is one of the hallmarks of a police state. People throw that term around like sort of casually. Oh, this is a police state. That's a police state. But like, this is one of the things that a police state is about giving the police the power to make laws as opposed to just enforce them. So that was the argument here. Now, the court notes the role of the, it says the firearms and their variants are prohibited based on the criminal code and the regulations. The role of the Specialized Firearms Support Service, the RCMP, in assessing and classifying firearms as non-restricted, restricted, or prohibited reflects the opinion of the Specialized Firearms Support Service. The firearm reference table sets out the results of their assessment. It is an administrative resource or guide for firearm owners and others, i.e., it's just their opinion. However, it's actually the government that decided what was banned. So they didn't agree with this argument either. Now, this is the one that's a lot of people are quoting, and a lot of people are upset about, and I'm going to try to explain it because it's not as crazy as it sounds, but it is also going to be, or when I say it's not as crazy as it sounds, what I mean by that is that this is long established by precedent, even though it's going to offend a lot of people. So here's the line. The governor and council does not owe a duty of procedural fairness to firearm owners affected by the regulations. Lots of people very upset by that line because they're just learning this for the first time. The government owes us very little about how they go about making decisions and how they go about that. So there are very few people who are owed a duty of fairness by the governor and council. And specifically where there's Indigenous people and Indigenous rights issues, the government may have a duty to consult, which is really a procedural fairness obligation towards the Indigenous people. But towards, other or in areas that don't touch on Indigenous rights or just towards people in general, they don't actually owe you any sort of duty of procedural fairness. They don't have to consult you before they pass a law that affects you. They don't have to give you an opportunity to respond to them or anything like that. So the jurisprudence is clear that the duty of procedural fairness does not apply to the legislative process, nor does the Specialized Firearms Support Service owe any duty of procedural fairness to firearm owners in the context of its assessment and classification of firearms. The Specialized Firearms Support Service is not an administrative decision maker. Now, I just want to say a couple of things here. First, the so the government doesn't, like, if the government wants to ban fentanyl, like when they decide fentanyl is banned, they don't have to reach out to fentanyl users to say, hey, what's your opinion on this? They also don't have to, they don't have to consult. They don't have to anything like that. They can just make that call on their own, right? So that's really what that means. But now, some of you know that I'm also locked in a battle with the government on my own. I have my own fight going on with the government here. And that is over a related issue. It's related to the Order in Council, but it's with regards to whether or not they had a duty of procedural fairness to us. And this is not the legislative group. This is the Registrar of Firearms. So, this is bad that it was lost on the Order in Council, right? I'm sad that they lost the Order in Council thing, because ultimately, if they'd won that, my application becomes kind of meaningless, which is kind of nice, right? That is kind of awesome. However, here's the flip side of this. The flip side is that when they say that the Specialized Firearm Support Service is not an administrative decision maker, this is going to be big in my case. And my case, I'm just now going to be appealing up to the Court of Appeal. I've got to get that notice in. I haven't filed it yet, but I'm going to be filing it. And so, what is it? When I file that, I am going to be mentioning the decision in this case as because I have to actually apply for what's called leave to appeal. And leave to appeal means essentially that I have to go up and argue with the, I have to argue that I should have the right to appeal. And that's heard by the Court of Appeal. Like, the Court of Appeal will make the decision as to whether I get to do a full appeal. But I am going to be pointing out, amongst other things, that this decision directly contradicts some of the arguments that were being made by the government, and therefore that this says that I should get heard at the Court of Appeal, which is beautiful, right? Now, so this is kind of mixed. It's bad in the context of the of this case. It's kind of good for my case. And so, yeah. Now, they also note here, the regulations do not infringe Section 7 of the Charter. The regulations are not vague, overbroad, or arbitrary. What this means, to explain what this means, laws can't be vague or arbitrary. And and it's an example of a vague law. You can't have a law that says it is illegal, it shall be a crime to be a vagrant. Because what is a vagrant? Or you can't have a law that says it is a crime to be antisocial. Because what does antisocial mean, right? Does antisocial mean that I can't be the kind of person who spray paints things on walls? Okay. What does it mean that I can't be the sort of person who just doesn't like hanging out with other people? Does it mean that I can't be the sort of person who protests? What does that mean, right? What does it mean to be antisocial? It's unclear. Laws have to provide you with sufficient information about, or sufficient specificity about what they capture in order to actually allow you to guide your behavior, right? In order to actually allow you to decide what you can and can't do. So, like saying mischief laws where you can't break other people's property, that's pretty clear, right? That tells me that I can't do all sorts of things. I can't spray paint the neighbor's car. I can't slash his tires. I can't set fire to it. I can't any of those things, right? That tells me that what I can and can't do. But if I just can't be antisocial, I don't know what that means. And so I don't actually know how to regulate my behavior in order to comply with the law. And I don't know when my behavior takes me at risk of being pursued by it. Now, they also say, alternatively, now the court is making sort of an alternative verdict saying if I didn't find, if I did find that it breached the regulations, they would have found that that any infringement is justified pursuant to Section 1 of the Charter as a reasonable limit. This is one of those parts of our Charter of Rights and Freedoms that horrifies Americans and a lot of Canadians. So the rights in our charter basically say that they are only guaranteed to the extent that is, or that any infringement has to be demonstrably justified in a free and democratic society. And what that means is that the government can actually violate rights and can pass laws that violate rights. And the courts can say, oh, but that's fine. This violates your rights, but that's okay. We're not going to worry about it. A classic example of this is the laws that allow police to do road checks. And so there are laws in just about every province, I think every province, that say that the police can set up a road check where they just block off a road and stop literally every driver who's driving down it and give them an eyeballing to see if they want to ask them to provide a breath sample and to, basically for driver screening. And the government, or like the courts have said, this violates your rights to not be stopped not be arbitrarily detained, without any purpose. And however, they've also said that this is fine, that the government is allowed to do it, even though it violates your rights. I don't really like Section 1 of the Charter. Or at least I can see why they put it in, but I would actually have put it in. I would have changed the wording a lot on Section 1. Now, I'm just going to note this kind of alternative decision, like if I had found that it violates rights, I would have said it was saved by Section 1. This kind of alternative decision-making on rights issues, the appeals courts have said doesn't really carry a lot of weight. And the reason why is because how can you decide whether a rights infringement is justified when you didn't think it was a rights infringement in the first place? So I've run appeals where the courts have said, and if we did find it was a violation of rights, we would have allowed the evidence in anyway, for example. And the court has been like, well, yeah, we're not putting a lot of weight on this. So I don't think that at the Court of Appeal, this alternative argument would take a lot of, issues on that. So, or that they'd put a lot of weight on it. Now they say the regulations have a pressing and substantial objective and are a proportional response to that objective. This is part of the test for Section 1 analysis. Pressing and substantial objective, which means you can't violate rights under Section 1, and save it under Section 1 if your purpose is like aesthetics or something like that. But they almost always meet that test. Proportionality. They might say that there is a pressing and substantial objective in preventing people from committing mischief, like damaging your neighbor's car, slashing their tires, etc. However, they will not say that it is proportional to have summary execution if the police think that you have slashed a tire. And they say the regulations restriction on the now prohibited firearms that are inherently dangerous and have the capacity to inflict severe harm, and as a result are not reasonable for use in hunting and sport. That is a factual conclusion that they made, and I disagree with this factual conclusion because I know a lot of people whose hunting rifles were in fact captured by this. So, and whose sporting rifles were captured by this. I own 2 ARs. What did I do with the AR-15s? I used them for sport. 3-gun. That's what I used them for. So they say the minimal infringement of firearm owners who now have less choice in the firearms they can possess and use, who could face criminal charges if they continue to use the now prohibited firearms, is outweighed by the beneficial impact in terms of reducing the harm from mass shootings and the inherent danger posed by the now prohibited firearms, and achieving the broader objective of enhancing public safety. I'm just going to tell you guys, the benefit here is zero. This is not actually going to stop anything at all. But the government is allowed substantial latitude in being wrong. They also note the regulations do not infringe sections 8, 11, 15, or 26 of the Charter, and they do not infringe the Canadian Bill of Rights. I'm just going to note the Canadian Bill of Rights is toothless and doesn't have any actual power. The Canadian Bill of Rights is a law that was passed to basically declare that Canadians have certain rights. However, the problem is it wasn't actually enshrined in the Constitution. It's not a constitutional law. It's just a law, same as the criminal code, right? There's a difference. Constitution is the highest law of the land. Other laws are subordinate and in this sort of category here, and it's in that category. And the reason why that matters is because any law that is passed after one law is deemed to overwrite that previous law to the extent that they are in conflict. So, for example, if the federal government passes a law that says it is illegal to wear a green shirt, and then later they pass another law that says it is legal to wear a green shirt, that second law overwrites the first law, right? To the extent that they're in conflict. This is just a general principle of how laws are made. So when you apply that to the Canadian Bill of Rights, the Bill of Rights is overwritten by any law that violates the Bill of Rights, which means it's completely useless. There is all of one person in the history of ever who has given a remedy or been given a remedy via the Canadian Bill of Rights. The Canadian Bill of Rights is a trash document, and I like the Bill of Rights because it includes things like property rights, which are not in the Charter of Rights, but it is a useless document overall. Now, these were the arguments advanced by Ms. Genereux, and Ms. Genereux is a self-represented individual. She's making arguments that I don't think were likely to succeed. She was trying real hard, and she's in a very difficult context. I give her all the points for giving it her best go on this one. She tried her best. And yeah. So, there's a few things I'm going to point out in this, and then I'm going to move on from this one because I am going to do a very lengthy breakdown of this case in future. And the very lengthy breakdown of this case, it's going to be a bit. Expect it to be like a week at least for me to get this out. Because I'm going to have to go through all of this. I'm going to have to highlight it. I'm going to have to make tough choices about what I include, what I don't include. And yeah. So the first thing I'm going to draw is basically the people appealing wanted what's called an adverse inference. And an adverse inference is essentially that they say, so let's think of a good example. Alibis. Let's say you have an alibi, right? You're accused of a murder and you say, I didn't do the murder because I was in another place. Like the murder is said to have happened in British Columbia. And you're like, no, I was in Quebec at the time, right? that's an alibi, right? I couldn't have done it. I was somewhere else. Now, oh, and I'm being reminded I've got the November 4th. Might be a little bit long. So Ben is asking, how about the CCFR versus Canada federal court decision that came out today? That is what we're looking at. That's this. That is this. That's what we're covering right now. So there's a rule for alibis that says that you have to give notice to the prosecution when you're going to be running an alibi defense. And the reason why is because you basically have to let them investigate your alibi. You know, so that, let's say I say I couldn't have done the murder, I was in Quebec. They can look and they can check. They can say, oh, wow, were you like, and in some cases, I have filed an alibi notice and and they've actually said, oh, we checked out your alibi and it turns out your alibi is true. So we're going to drop the charges, which is like fantastic, right? I had one where it was literally my guy was in a restaurant and he came to me and he's like, I didn't commit this crime because here's my receipt from when I paid at the restaurant. I sat down, I had a big meal, I was there with friends, we had drinks, we had dinner, we had all of this stuff, and then here's my receipt, and it's got a timestamp on the receipt, right? So, and I was like, cool. So I sent that alibi notice to the prosecution, and the prosecution like sent the cops to investigate. They actually went to that restaurant and they pulled the security camera video from the restaurant. And they came back and they said, yeah, we can see your client. He's sitting there, he's eating. He didn't do the crime. But let's say we flip that around. Let's say I file that alibi notice and say my guy was at a restaurant and they pull the security video and they say, like somebody used your guy's credit card but he wasn't there. Like we actually looked at the security camera footage and he wasn't at that restaurant. We've disproven your alibi notice. That's going to be real bad for your case, right? So let's say you instead, like, let's say, I get to the day of trial and my client gets up on the stand and says, I couldn't do it. I was at the restaurant and I haven't filed alibi notice. There's going to be an adverse inference where the court is going to presume that the reason why I didn't give them alibi notice is because they would have investigated and found it to be false. There's actually this presumption that the failure to give notice was for a bad purpose. Now, that's only a presumption. Like, it's only, it's an adverse inference, but it isn't conclusive. The court can still say, I agree that your client was at the restaurant. I'm going to acquit. But it's still an adverse inference. So in this case, the people appealing or challenging this decision were asking for an adverse inference because the government refused to give the record of how they made this decision. Now, this is substantially kind of the issue because the issue at hand here is that, it's like, did they actually come to the conclusion that these are not suitable for sport and so forth? Did they make a reasonable decision on that one? And so the court's ruling is this: no adverse inference should be drawn. And so basically they say that because it's in their authority to refuse to give this information up, that they are not going to draw an adverse inference. This was a loss for the people challenging this decision. And really, it's a loss for people who don't want untrammeled government power, because this really is a situation. We're in a world now where the government tends to make decisions secretively, and then we just all have to live with it and kind of take their word for it when they say that they made those decisions reasonably. So that's one aspect of things. And another aspect here is, I'm just trying to look here as to the review process here, or just trying to find the right section here. Sorry, I'm just trying to find this. So classification is not immune from review, so a review process exists. So they say courts ultimately determine whether a variant is a prohibited firearm. So the applicant's concern about facing and defending charges of possession of prohibited firearm, which they dispute is prohibited or which they may not know to be prohibited, are valid concerns. But the court has to prove this. Whether an unnamed variant is a prohibited firearm is a determination that will be made by the court. So, what is it? And they actually they rely on Henderson, which was a case that is an appeal of the Registrar of Firearms' decision to refuse a registration certificate for an Army Jaeger AP-80, an unnamed variant of the AK-47. So this is big for me. Keep in mind, I've got my separate challenge. This is also really helpful for my challenge of the government. It sucks for me and for gun owners that we lost today, but there is this, I guess, little spark of light in this loss. It's like when your house burns down, you're like, well, at least I can use the ashes to light my cigarette. That's kind of what we're looking at here. So I'm going to be making use of this when I challenge this decision and say, listen, they actually confirm in the federal court the decision-making process where this goes to the provincial court. And so now that we have this decision that the provincial or that the federal court says it goes to the provincial court, I think it's going to be really hard for the Court of Appeal to say, wait, this has got to go to the, to anywhere else. So, yeah, this I think is going to be useful in this, this regard. So they relied on a case, the Queen and Baco, so Mr. Hipwell, an applicant, acknowledges that the FRT reflects the opinion of the SFSS regarding the classification of a firearm, that it will ultimately be up to a court to determine if the firearm is prohibited where such charges are laid. This was Mr. Burlew's position, and I think he was correct on that point. Now they also note that there is so I'm just looking here as to where's the line that I was looking at. So they say quality assurance review process. So there's actually an element, and I can't really find it here. I'm going to wrap this this case up fairly quickly here. But they also note that there is a process for challenging things in provincial court. And I'm going to find that quote, and I'm going to, I'm going to rely on that and note, hey, the people who do owe a duty of procedural fairness are are that. So they say, moreover, there is a process for a firearm owner to request a review of the classification of a firearm, as explained by Mr. Smith and as acknowledged by Mr. Hipwell, an applicant, as noted by the AGC, in the event that a firearm owner is charged with an offense or faces other consequences arising from final decisions made by another administrative decision maker, like the registrar, the firearm owner would be afforded all the procedural and charter rights that arise in that context, i.e., you get to challenge them in court. So there is some in this case that is going to be helpful to me in my fight with the government. But it is a loss for Canadian gun owners at the moment. I'm seeing people saying that the only resolution they can get is 720. I'm actually, for some reason, locked to 720. That is annoying. Sorry, folks. Hopefully you guys can still read this. So, as I mentioned, I have a trial tomorrow, and I'm going to be getting ready to run that trial. I'm hoping that's a trial that later down the road I'll be able to share with you guys, but we'll see, right? So I'm going to try to run that trial later on. or I'm gonna run that trial, and hopefully I'll be able to share it with you later on. But I got to be ready for it, so I can't run this till all out. Whoops, sorry. I'm drinking an electric unicorn here. I can't run this to all hours because I'm going to go over my trial prep again and get ready for it again. And then I'm going to try to get some sleep. I want to be rested and ready to go and in fine form for when I challenge, when I get into this fight tomorrow. The fight tomorrow is a landlord tenant issue. And yeah, it's we're just looking to fight that one. So, but I gotta be ready. I gotta be in good shape for it. I am also not feeling 100%. When I say not feeling 100%, my back has been killing me. I am in a lot of pain right now, and I didn't get a lot of sleep last night. I got about 4 hours of sleep last night. I took a couple of naps today, but it was a little rough, and so, and I'm having stomach issues. So, yeah. So we're not gonna go too late, but I do still want to cover a bunch of things because there's a bunch of fun stuff today. So that is something we're we're looking at this one, but we're gonna also cover some other fun stuff. Flying Bee versus Electric Unicorn. It is a kind of it's like a light IPA. It's kind of weird, and I kind of like it. All right. I also want to cover something that has been showing up on Twitter. And Twitter is a wretched hive of scum and villainy, but sometimes people ask interesting questions on it. And so the one that I want to look at right now involves sports ball. We're going to cover some sports ball. And so what happens in this video clip is we're going to actually see this is, and just in case, do I still have that? Do I still have the viewer discretion bumper? I do. So let's hit the viewer discretion bumper. All right. So what we're going to see here is a death. And the question that comes up is this an accident, which is what the official story has been so far, or is this intentional? And if it's intentional, what would we be looking at in terms of charges and so forth, right? What would we be considering this? So let's have a look at what happens here. And I'm going to try to stop it after the actual injury, but before we see any of the real, before we see anything like that. Now, it's going to be up in this sort of up in the middle here. It's this red guy skating up to this white guy. All right, so we're going to go back to that. And again. Now, the question is, was that intentional or not? And the reason why I ask this one is because what ends up happening is you may not realize this, hockey skates are super sharp. And they're sharp because you need to have good traction on ice, right? So they're little blades. And basically this guy gets kicked in the neck. And he gets hit in the neck with this hockey skate, and it slashes him, and he does not survive. He doesn't make it. Now, he's said it's an accident. A lot of other people have watched this video clip and said that it looks intentional. I can say I have watched more hockey than I would like to have in my life. And I've never seen anybody get hit like that. I've never seen anybody actually get hit like that one. So, I I am unsure. And ultimately, if this were to go to a court, the jury or the judge, whoever was making the decision, would have to watch this and look at whether that was intentional or an accident. Now, here's the thing, and I see somebody saying, play it again. We can... Now, here's the thing. If it's an accident, then he will be acquitted. Then he will be cleared. Because if it's an accident, you're not going to be held at fault for an accident. That's the same in the UK as here. Now, that I should put some provisos on it. If it's an accident where you're behaving recklessly or doing something in violation of a duty, you may still be held at fault. If you've seen the movie The Lookout, there is a moment where a guy is driving and he turns off his lights to drive at night, and they end up slamming into a combine, like in the dark. If that's the case where you're doing something in a fashion that is like wildly reckless, or let's say, for example, let's say I grab a gun and I just decide I want to make some noise, so I just kind of shoot randomly out my window, and that hits somebody. You can be held at fault for that kind of action. But if something is a pure accident, then you're not going to be held at fault. So as an example of a pure accident, let's say you're driving down the highway and there's a wasp that gets in the car, and that wasp stings you somewhere real sensitive, and you just like jerk the wheel out of a reaction to that, right? It wasn't an intentional action, and it wasn't, that kind of accident. Or you're driving your car down the road and your brakes fail and you get into an accident because of that. Purely accidental things where there's no fault element on your own. So if he's actually tripping in that video, like if he's falling and sending his leg up to try to steady himself, which is what some have suggested, then he will ultimately be acquitted on this. Ultimately, that would be, and he shouldn't even be charged if that's what they believe there, right? But let's consider the other possibilities. Let's say it's intentional, and somebody says the player in the white jersey is the one who died. Correct. Let's say it's intentional. Well, if it's intentional, now we're in a different scenario. Because in the UK, the law basically says a murder includes if you intend to cause somebody either death or a very serious injury, and they die from that very serious injury that you intended to cause them. There are some further like provisos and wrinkles about like if this ends up going to, for example, you can have transferred intent where, if you try to shoot one guy and you miss, you hit a different guy, you can be convicted of killing that other guy, even though you never intended to actually hit that person. But, and the reason why I keep mentioning the UK is that this actually happens in, the UK. And, all right. So, but let's say you've got something in, let's consider what would happen if this happens in Canada. In Canada, I don't think you would ever be able to prove specific intent to kill. And that's kind of what's required. I'm generalizing a little bit here, but in order to get to murder. So even if he intended to slash the guy here, I don't think that they would say this is a murder, because I don't think that they would say that he actually intended to kill the guy with this thing. Even if he intended to actually, and somebody says, would that be Sheffield versus Nottingham? Yes, it would. So even if you just intended to injure the guy, that would be enough to get to manslaughter, because it would be a wrongful act. It would be an intentional attack, an intentional assault that causes a death. Now, manslaughter is a fun, and I say fun, is fun in the sense that it has very open-ended sentencing. The minimum punishment for manslaughter is an absolute discharge, which means, the minimum punishment is like no punishment at all. They can just like be like, nope, we're not punishing you on this. However, the maximum punishment, I believe, is life. I got to check that. It's been a while since I had to actually deal with a manslaughter sentencing. So, and that was just an appeal review. So I'm just checking the criminal code again. All right, let's pull up the sentencing on manslaughter. I believe it's life, but I got to check. So that's section 239, if I recall. No, that's attempt. Manslaughter 236. Yeah, so the maximum punishment is life. The minimum punishment is, there is no minimum. So, yes. Jacob, it has been discussed. I was mentioning, unfortunately, the court kind of deals with some of the Generu positions kind of casually, at least in the decision, ultimately. But we did discuss it. If you go back to the beginning, you'll see it. Jacob, I believe, is one of the applicants. And I just want to say the Generu group, who were self-represented, conducted themselves amazingly, considering how brutal federal court is. Federal court is so difficult, and I was impressed as hell by the ability that people had to, by what they brought to the table here. Some of the arguments are ones I don't think were ultimately likely to be successful, but I mean, they put a lot of research in and a lot of that. And quite frankly, even though people were unsuccessful at that, I think we all owe them a debt for having the courage to stand up. So, Mr. Generu, I lift a glass. So, a lot of question here as to whether or not this was intentional. And I see, not related. Okay, fair enough. My mistake. I thought it was a Jacob Generu on that one. Now I'm just pulling it up. Now I'm checking the Generu group. My bad. Generu. No, it's Christine Generu is the only one on that one. So, yeah, the Generus were, or Christine Generu did, yeah. Now, I actually think, ultimately, and JR, thank you so much. That is exactly where I was going to go on this one. I ultimately think this one would be a very difficult one to get a conviction on. Here's the thing. My view on this one, I say, I think that he meant to kick him. Now, some of my basis for I think he meant to kick him is going to be based on things that would be inadmissible at trial. One thing people have said is, listen, he has a bad disciplinary record. This guy's got a record for playing dirty. Well, you know what you can't tender at a trial? You can't tender that past history to say, this is a bad guy. This is a guy who plays dirty. Therefore, he was probably playing dirty here. You just can't do it. CG, I do have a PayPal. Shoot me an email. If I put it up publicly, I get a whole bunch of hacking attempts and so forth. But if you shoot me an email, but I do see, and I'm just going to go back to it, and I'm just going to say, this is what I'd be thinking if I was on the jury. Because if I'm on the jury, I'm not going to actually hear that he's a dirty player, right? And you see how he goes for a hip check, and he misses the hip check. I don't even know, if I'm looking at this, I'm going, I think maybe that was an attempt at a kick, but I have played no hockey whatsoever. I'm not a good skater, but I did play soccer, and I can tell you when I played soccer, I ran into people on occasion, and it wasn't on purpose. It's just this thing happens, and you see, we're gonna watch this again. You see how he's going up to the one white player, and he misses him. He would have focus on that guy that he's trying to hip check. I'm pretty sure he would be focused on that guy. And he may not have even known the other guy was there when he took that hip check motion. Now, watching it, I still think intentional. That's my feeling. But if you put me on a jury and you say, are you at proof beyond a reasonable doubt that this was intentional? I go, no, I'm only at like 70%. And at 70%, I go, I can't convict on that. I think he did it. And if I was on a jury, I would have quit. And when I say I would have quit, if everybody else on that jury was saying, I want to convict this guy, I think he should go to jail for however long, I would say, tough crap. We are not convicting this guy. I am not sufficiently certain that. And Kestrel has an excellent point. 70% wins a civil lawsuit. Yes, it does. But it loses a criminal case. So and here's the other thing. If I am the police, I would not charge him. And if I would not approve this charge if I was a prosecutor asked to do charge approval. I don't think he meant to slash the guy with his skates. So I think he did mean it. I just don't think you will ever get to a situation where the where the jury would convict. So that's, I've had a lot of people asking about this one. And yeah. See, Google NHL hip checks. These guys' feet are always way up high. Fair. I don't actually know on that one. So Philip Martin, lose a criminal case or should lose a criminal case to 70% lose in practice or only on paper. I mean, in truth, we don't actually know what's happening with the jury, right? We don't know. So yeah. And this is a different question. If I was the coach, he's off the team permanently. That's a different question. Because the coach can make their own rules on that one, right? The coach can make their own, their own decisions on that one. So yeah, I don't think you'd ever get to murder on this one. I think manslaughter is a very big reach. And I think that most likely he just gets acquitted. But we had another case here in Edmonton. And this is the one that JR mentioned. And then after we look at this, we'll do a swoop and do some super chats here. So JR mentioned 2 weeks ago in Edmonton, there was a player that stomped on another guy's neck with his skate. That one needed stitches, and the other guy got 3 games. This one, so the allegation, and I don't know the facts of it because, of course, I wasn't there. I'm just reading news articles. But the allegation was that one player went up, and I'm just going to pull this down here. And this, I think, was a youth game, kids. That one player went up and stomped on the other guy's neck intentionally and cut him quite badly. Now, I saw the injuries on that one, and the injuries are to the back of his neck, not the front of his neck. And so, but it sent him to the hospital, right? It sent him to the hospital, and the guy had to get stitches and a whole bunch. It's a really nasty slash on that one. And I'm going, they should charge that one, right? Oh, I see 20-year-olds, young but not kids. That's a big deal because if they're 20-year-olds, then they're not under the Youth Criminal Justice Act, and they get full adult punishments. So that one I would charge. Now, I've seen people say on that one that they want to charge of attempt murder, and I'm going to say there is no way they get a conviction on attempt murder based on that neck stopping. It's just not going to happen. Attempt murder is harder to prove than murder. Attempt murder is a very hard thing to prove. It's just, you have to prove an intention to kill somebody, not an intention to hurt them, not an intention to cause them serious injuries, an intention to kill them. I don't think they're going to get there on that one, but I do think that they could get there to aggravated assault. And aggravated assault is an assault that wounds, maims, injures, or disfigures. And on that one, they get, this guy's got a serious slash. People misunderstand what aggravated assault means. They say, oh, I was aggravated, so it's less serious. Actually, the guy who's charged with simple assault, and he's like, can I plead to aggravated assault instead? And I was like, no, we're not doing that, because aggravated assault is more serious. It's worse. So aggravated assault, I think they can make the case for on that one. And I think that they could probably get a decent conviction. The other thing I would charge him for, and I'd charge both, is assault with a weapon. And the weapon in this case is skates. Now, I saw somebody saying assault with a deadly weapon. This case that we're now talking about, the youth case, happens in Edmonton. And so we're under Canadian law. And under Canadian law, you don't actually have an assault with a deadly weapons specifier. It's actually just, assault that is with any weapon. So it's assault with a weapon if you pull out a shotgun and shoot at somebody. It's assault with a weapon if you throw, this can of Coke, which currently has Coke in it, so it's got some mass to it. If I yeeted this at somebody, that would be assault with a weapon. If I swing a bat at somebody, that's assault with a weapon. If I pull a knife and make like a stabbing motion at somebody, even if I don't connect, that would be assault with a weapon. Now, why do you charge both? Well, in Canada, you can get what's called a lesser and included offense conviction. And so what that means is, let's say I charge somebody with, the government charges somebody with murder, and they don't convict on the murder. They can still convict on any offense that is what they call lesser and included. So the lesser part means that it is, the lesser means that it is a less serious offense. You can't go up. So if the prosecution has charged assault, you can't convict on assault or an aggravated assault, even if ultimately you determine that that it was an aggravated assault. You can't go up from the original charge, but you can go down. And included means that every element of the offense, every sub portion of the offense, of the lesser offense, has to be included in the greater offense. So aggravated assault, for example, is exactly the same elements as assault, plus the element of, did you actually, did you cause serious injury and so forth? Did you cause somebody disfigurement or, life-threatening injuries or some sort of serious injury? So if you don't convict on the aggravated assault, you can still convict on the lesser assault. So as an example, there's a case I was reviewing not too long ago where somebody got into a bar fight and punched another dude in the face. And that guy went to the court and said, I had a skull fracture. Skull fracture is good for aggravated assault, right? That's enough to be a serious injury like that. But the court didn't actually believe that the skull fracture came from that bar fight because this guy got into some other injuries and some other, sort of issues. And so the court was like, we're not actually convinced that his skull fracture was related to the bar fight. at least not to beyond a reasonable doubt, and therefore, therefore that's we're not convicting on the aggravated assault, but they did still convict on the assault. So the problem is aggravated assault with a weapon is not lesser and included to the offense of aggravated assault because it has a new element. That new element is the weapon, right? So aggravated assault doesn't require that you have a weapon. This weapon is a new thing that wasn't included in the aggravated assault, and so it has to be charged separately. So properly, the way you would charge that offense is 1 count aggravated assault, 1 count assault with a weapon. And then that person is then on notice that they have to defend against all of those issues. All right, let's do a swoop and let's review some super chats here. I still don't have my good new dog swoop done, so we're gonna do previous dog swoop. Doggos. All right, let's look at some super chats. So, Paladin Phil says, my worry is that it'll be a step against our guns. They're going to keep coming for sure. Kurt Eaton says, thanks for covering this important decision. I'm going to do another video going through it in some detail. We're going to get that done. Eugen 813, people have said this means they don't need to do compensation for the newly banned firearms. I'm going to tell you they never did need to do compensation. Legally speaking, they never did need to do compensation. The reason why they're doing compensation is political, right? It's because people will be upset if they're taking huge amounts of money from people, like property from people, without compensation. But, if you are sitting on $1 million of fentanyl and the government bans fentanyl, they don't actually have to pay you anything for that action in Canada. So, yeah. Justin Force says, pain. I'm not sure if you're referring to my back or the court decision, but in either case, you're correct. Angie Torres, thank you so much for the super sticker. Much appreciated. Dina Kawaji, thank you so much for the super sticker there as well. It's much appreciated. Equality, thank you for 5 gifted memberships. And I see Unnamed Firestorm. Good evening, squad. Good evening. Nicholas Staro's Trial Watch. Hockey in Sweden. Players are responsible over their equipment. Players have been prosecuted over it. Yep. In Canada, there have been prosecutions too for like fighting injuries or slashing or whatever else. Have you seen a case where defense attorneys seem to forget to defend against one of the charges? I have. I have actually seen a case where a defense attorney basically seemed to forget that a charge existed, and it didn't go well for them. I was watching that case, and I was like, dude, I think that he actually forgot that it was on the, this, and I'm not going to name the lawyer, but I think he forgot that the charge was actually laid against his client because he was basically admitting that charge without actually just pleading guilty to it. So, yeah, it does happen. But I mean, nobody is perfect at their job. People make mistakes all the time. So it is what it is. All right. So that one is one that's got us all disappointed. And, so that's our super chats. Sort of a quiet night, but that's okay. We're going to look at, so Murdaugh is making a motion for a new trial. And that's going to be interesting. I think I've got the wrong PDF here, though. So when was this one filed? Nope, this is October 27th. They're making their motion. So this is new. This is the new thing here. And I got to do a new share screen. Murdaugh is making a motion for a new trial. So, defendant Richard Alexander Murdaugh, through undersigned counsel, pursuant to Rule 29B of the South Carolina Rules of Criminal Procedure, hereby moves the court for a new trial after discovering that the clerk of court tampered with the jury by advising them not to believe Murdaugh's testimony and other evidence presented by the defense, pressuring them to reach a quick guilty verdict, and even misrepresenting critical and material information to the trial judge in a campaign to remove a juror she believed to be favorable to the defense. Now, ultimately, all of these allegations are things that they're going to have to prove in court. But essentially, they're saying that the clerk of the court got involved in this, and they're arguing that the clerk of the court got involved in this in order to benefit her book deal. So, yeah. Now, this is an excellent comment. We knew this was coming. We absolutely did. And how do we know this? They told us it was coming. They actually told the appeals court, hey, we're doing this. So obviously they were going to do it. Now, a lot of this I covered previously. And I see somebody saying, I miss Rob, but I can't handle the Maya case. I can't blame you. Is Rob still going? I tried to push this a little late so Rob would have time to wrap up, but I know Rob tends to run long, so in the same way that I did. Yeah, she didn't have a book deal. She self-published, it looks like. So all of this is going to be, and I'm just going to say, the allegations are real bad. The allegations are real ugly. That doesn't mean that the allegations are necessarily true. Every time you see that there are allegations, that's all they are, right? They're just suggestions about what happened, and they have to be proven in court. Did her book really make any money? I'm going to say her book probably didn't. Self-published books usually lose money. And so there is a substantial possibility that she will have lost money. However, I actually suspect that the financial value of her book went up as a result of this proceeding. I think that more people might buy her book. Hell, Kurt on civil law bought a copy of her book because of this issue, like because of these issues. And so I suspect there's going to be a lot of people who did that. Now, I read some excerpts from her book, and her book is really bad. Like, I couldn't stand reading her book. So, yeah. Her book is so bad. So bad. Now, this is the other one. Could the court clerk countersue for defamation? Almost certainly not. The reason why not is because these were actually, like, this is a court filing, and you are protected from defamation in most cases in court filings. There are exceptions to that, but yeah. And this is where I land too. I think Murdaugh is guilty as sin, but if the allegations are shown to be true, he should get a new trial. Absolutely. If the allegations in this case are shown to be true, then the trial was fundamentally unfair, and he should get a new trial. Murdaugh may have done it, but if we're going to convict the dude, we should convict him in a fair trial, not a not a trial that is biased. Now, they say Ms. Hill invented a story about a Facebook post to remove a juror she believed might not vote guilty, pressured the jurors to reach a quick verdict, telling them that it shouldn't take long. Now, this one we're going to go through briefly because this one is 74 pages. I might do another stream just to go over all of this, right? And then here is the fun other bit. Becky Hill could sue for the press conference last month, however. Yep. Once you repeat that shit outside of court, then she's got a defamation claim. So, yeah. The other thing, yeah, focusing on her motive is a mistake. Yeah. So they note Ms. Hill began to enter the jury rooms often. Now, I'm just going to say, entering the jury room is one of the things I would expect of the court clerk. I would expect that the court clerk would have all sorts of business in the jury room. Because, for instance, they might be going, hey, what do y'all want to eat? Have you guys decided, like, is Chinese food okay with you guys? because like if you remember the Depp trial, occasionally we actually heard the judge discuss, and not just the Depp trial. We heard it in Paltrow. We've heard it in some other. I think we heard it in Rittenhouse, where I think Rittenhouse they actually did a lot of like on the record discussion where they're like, and dinner today is lasagna, or lunch today is going to be lasagna, or something like that, right? This is the sort of thing that the clerk is going to have to talk to them about, like, hey, all of these things. So, yeah. They say that she told the jurors as the defense began their case, y'all are going to hear things that will throw y'all off. Don't let this distract you or mislead you. That would be pretty serious because you don't want them denigrating defense counsel. Defense counsel should have exactly the same footing to present their case as the prosecution. They say Ms. Hill and juror 826, the new jury foreperson, on multiple occasions went to another room to have private conversations lasting 5 or 10 minutes, and sometimes they'd go into the single occupancy bathroom together. Never said anything about the content of those conversations to other jurors. Now, I'm just going to say, this may not actually mean shit. I'm 45 minutes early on that, but like, it could be the juror number 826 is like, hey, can I borrow a tampon? And sure, that is exactly the kind of conversation that they might have in private and not tell the other jurors about, right? Like, hey, it's a heavy flow day. Can you help me out? 100% that, and there's nothing going to be wrong about that, right? There's nothing going to be improper about that kind of conversation. So, like, I'm good. Like, that's fine. If she's saying like, hey, we're going to be having, if they're just talking about logistics of the jury operation, like, hey, are you guys comfortable? Is the thermostat fine? Is, all of those things. Like, all of that would be fine. Say, you cannot borrow it. I don't want it back. In Canada, we are way polite. We will ask to borrow things that are clearly not going to be returned. Like, hey, at the range, it'll be like, hey, can I borrow some ammunition? You're not giving it back. It's going down range, right? The guy certainly doesn't want the ammunition returned to him. You might say like, hey, can I, it's just, yeah, it's just casual, like, discussion. So this is politeness. Like, hey, can I borrow something? That's just all that is. Can I borrow a tissue? Yeah, you're not giving the tissue back. So all of this, I don't know. This one might be a big deal, might not. And in order to determine if it's a big deal, they're going to have an evidentiary hearing to determine all of that. And I think that they've actually got their evidentiary hearing. Now, when Murdaugh was about to testify, she told the jurors not to be fooled, is the allegation again. Watch him closely, look at his actions, and to look at his movements, which people took to mean that he was guilty. Yeah. You do not want ammo returned at high speed. Absolutely. Can I borrow a fry? Yeah. I don't want to, if somebody says I'm going to borrow borrow a French fry or, whatever, that they're going to return it. So, and this is a great one. Can I borrow a yellow tie? You know what? We're going to move hastily onwards. So all of this we've heard before in terms of the allegations of the Facebook, thing that was completely wrong. The Facebook thing could also be that she got that accidentally, yeah. Yeah, and this is why it gets to be contextual. Can I borrow my cordless drill from your garage? Kind of suggests like, hey, I want that back. But like, if you borrow a lawnmower, you expect to get the lawnmower back. But if you borrow a tissue, you don't expect the tissue back, right? All of this is contextual and, particular and so forth. So, yeah. unrelated person named Timothy Stone, who's unrelated. So all of these are basically the same allegations they made before. And one of the questions that's coming up is Judge Newman going to be able to hear this case? And I think he's not, because they say that he held an in-camera conference. Now, this is on transcript, so they've got the transcript, but Judge Newman is going to have to make this, might have to testify about things he was told that there aren't transcripts about, right? That they aren't, that aren't known. I think Judge Newman is a potential witness on this. And yeah, Ms. Hill once again asked her opinion regarding Ms. Murdaugh's guilt, which is a question you should never be asking a juror midway through the trial. Juror number 785 told her that Creighton Waters' closing was good, but that she still had questions. She asked what questions, and replied that she was concerned that no murder weapon was found. Ms. Hill then asked, well, what makes you think he's guilty? And they said Paul's video at the dog kennels. And then they told juror number 85 or 785 that everything Mr. Murdaugh has said has been lies, and that I should forget about the guns. They will never be seen again. I mean, this is, if that is substantiated, that is huge, right? So, this shouldn't take us long, and if they deliberated past 11 p.m., they'd be taken directly to a hotel, even though none were prepared to stay overnight. That's also concerning. Like, jurors should be told that they will be made comfortable for the long haul if necessary, right? Ms. Hill told jurors after the trial they'd be famous, and predicted that the media would request interviews with them, and handed out reporters' business cards to jurors during the trial. This is also ridiculous, right? Jurors should be making decisions on the basis of the case, and not on the basis of whether or not they might make an appearance on the news or whatever else. And there's some interesting aspects. One of them I think will be really interesting to check here is juror number 578 took this to heart and made an appearance on Good Morning America the night of the verdict, which is why on the day the jury began deliberations, he wore a suit coat for the first time during the trial. Now, I mean, that if his plan was to make statements immediately afterwards, that is concerning enough that I might have wanted that juror removed in the first place. But now here's the thing. Yeah. Now they say she got her book deal. I don't think that there's a book deal. She's got a book, her book Behind the Doors of Justice, but I don't think she actually got a book deal. I think that the evidence we've seen says that this is a self-published work. And self-publishing, guys, self-publishing is almost exclusively a scam. There are some people who make big money self-publishing. I think Larry Correa self-publishes, but a lot of the people who self-publish are people who can't publish normally and are paying for their own books and end up, like a lot of people end up losing money on the self-publishing. And that's an issue. Now, this is where I think he publishes through Tor. Okay, I didn't know that. I follow him on Twitter. I should know better. But so they say, yeah. Now, this is one thing that I thought is extremely concerning before. She sent a memorandum where she basically demands that they push her book, right? It basically demands that they push her book. Also, in exchange for the use of the likeness of Rebecca Hill in an interview, a minimum of 5-second video and audio clips will accompany the usage on the first reference. The book cover for the book Behind the Doors of Justice, The Murdaugh Murders, will be shown, and audio will include Becky's introduction as clerk of the court for Culleton County and author of the book, i.e., she tried to put an advertisement for her book in the contract to use courthouse facilities. If this is true, if this is accurate, then not only should there be a new trial, like, the new trial is a separate issue. If this is accurate, then she should go to jail. Like, this looks like crime to me. This looks like corruption. And, so Becky Hill I think Becky Hill has a lawyer, and she should absolutely have a lawyer, because this to me feels like crime. And certainly that is the allegation that Murdaugh's team makes, and says, but like her jury tampering during trial, it was an attempt to violate South Carolina code, which provides that no public official, public member, or legal or public employee may knowingly use his official office, membership, or employment to obtain an economic interest for himself. Economic interest is absolutely made out. The value of an advertisement is absolutely, that's absolutely an economic interest. I can tell you that, like, to get an ad spot, like, let's say I wanted to market Runkle of the Bailey on Good Morning America or whatever else, right? That'd cost me a ton of money, a whole heap ton of money. I can't just market it on, on these things for nothing. I'd have to actually pay for that. And yeah. Oh, and I'm seeing it's Bain Books. Okay. Does anyone know where James from Court went? He disappeared after Murdaugh's case. James from Court sort of he comes and then he vanishes for a bit. I'm worried about the guy too. I hope he's all right. I don't know him all that well, but I liked him when I talked to him. Somebody says I thought he went to law school. He may well have, and he may be just too freaking busy to make these appearances, because law school is its own special hell. So, I see James doesn't want to be a content creator. I cannot blame him for that. It's a tough business itself. So legal standard, when the defendant presents a credible allegation, the defendant has an entitlement to an evidentiary hearing. I think they're going to have an evidentiary hearing on this. I think they're going to have to do that. And I see DUI guy has contact with him. He's okay. That's good. So the presumption is even stronger where it's a court official. So we're going to skip over a lot of the arguments and a lot of the details here, but that's basically what's happening here. They've actually finally brought an application for a new trial. I think this is going to come down to the evidentiary hearing. They're going to have to discuss and determine whether or not Becky Hill did the things that they say she did. Because if she did these things and the court determines that that is the case, then there should be a new trial. And in fact, quite possibly 2 new trials, because like they'd have to have a trial for Murdaugh, a new trial, and a trial for Becky Hill. And that would be interesting. Because I mean, I'd want to cover the Becky Hill trial. That seems like a fun trial to cover. Hey, did you do the corruption? So, yeah. All right. Now, I'm going to cover one last case. This one's a little bit old, but it is an interesting one. And this is the case of Brinks Incorporated, Brinks Global Services International, and Brinks Schweiz AG versus, or, the case of that, and, because it's Canada, so we'll usually say and, Air Canada. So what happened here? Well, somebody stole millions of dollars in gold from an Air Canada facility. And who's on the hook for that loss? Well, right now it's Brinks. And Brinks would like for it not to be Brinks. Brinks would like it to be Air Canada that ends up paying for this missing gold. So what Brinks is going to be arguing is that Air Canada screwed up and should have to pay for the missing gold. So, all right. Statement of claim. A legal proceeding has been commenced against you. This page is a required page that they just include. Whoops. And I've just accidentally opened a thing here. Why do they include this page? Because they're required to. And they're required to include it mostly for the benefit of people who aren't lawyers. A lot of people who get sued are not big businesses who have lawyers and legal teams who already know this. This tells you, like, you need to defend against this right away. And it gives you your deadlines and all of that, so that it's like, you need to get on this. So, yeah, and this is the heist from the Toronto airport. What are they suing for? 13,612,696.75 Swiss francs. I don't know what the hell that means. So, I am going to have to turn that. Let's do some currency conversion. So this is a lawsuit for $20,881,248.51 as of today. That's a lot of money. I'm just going to tell you, I don't have $20 million. I have no $1 million, $0 million. And so somebody's saying, why no Canadian money? I'm guessing it's because they, I'm guessing because they probably owe the money in Swiss francs. And so they want that decision. Dear Brinks, after review of your claim, Air Canada has determined you are not eligible for compensation. If you disagree with this decision, you may appeal to the CTA. Yeah. Now, you might be wondering, why is this in federal court? Well, federal court ends up hearing all of these airline disputes because of certain international treaties that are involved in this. So, yeah. I have none $1 million. That is correct. So, now this is amazing because I'm just like, this is an amazing heist story. People are going to make movies on this as to how somebody stole $20 million from an airport in gold. So, the parties. Brinks Incorporated is a Delaware corporation which conducts business as a global provider of cash and valuables management, digital retail solution, and ATM managed services. Brinks Global Services and Brinks Switzerland is a Delaware corporation or subsidiaries. And Brinks Switzerland is a corporation organized under the laws of the Canton of Zurich in Switzerland. So basically, Brinks is security, and Brinks allows for, travel or, if you want to move a whole bunch of gold bars, Brinks is one of those companies you might hire to do it, right? So, all right. Now, the AC Secure system. So this is Air Canada Secure. Provides special handling for high-value cargo, i.e., if you want to move high-value cargo, if you've got a shipment of diamonds or, fine art or whatever else, you might ship it via Air Canada Secure because you don't just throw that shit in your carry-on luggage. According to the Air Canada website, Air Canada Secure ensures the safe and secure transportation of specific commodities through various enhanced safety features, including extra security. They are supposedly kept in secured locking facilities and supervised by third-party security guards. Priority service, i.e. they get on the plane and off the plane faster. And in describing the types of shipments which qualify for Air Canada Secure, they list a number of commodities which, regardless of the declared value or amount of the insurance purchased, constitute high-value shipments. Emphasis added. Artworks, firearms and weapons, interesting. Furs, gold, silver, and gems, jewelry, pearls and watches, narcotics and controlled drugs, and negotiable paper, including money or currency notes, stocks and bonds, and traveler's checks, i.e., all the valuable things, right? Now, they say including, now there might be other things. As an example, if you had the Magic the Gathering One Ring card, you might be able to argue that that is a high-value shipment that qualifies for Air Canada Secure. Until the events described below, Brink's standard practice was to require that certain high-value shipments transported via Air Canada were handled via Air Canada Secure. Until the events described below, what might have changed? Oh, right, they had $20 million worth of stuff left or stolen. So, in or around March 2023, they say that there were ongoing upgrades designed to build an improved process, including better technology enhancements, handovers, and an improved tracing method. And they say, so this is key because they say they were promised these things, that they were told that these things were happening, and Air Canada failed to implement them. Devin says, who is shipping cash? Like sometimes banks might ship like literally millions of dollars, pallets of cash might be shipped via airlines. So, yeah. Air Canada charges higher shipping rates for the Air Canada Secure service than it does for the shipment of regular cargo. Of course they do. It's a premium service. All valuable shipments are assessed a flat handling fee in addition to a valuation charge that is calculated as a percentage of the declared value. So they take a cut, basically. The shipments. So this is what was missing. They can Raiffeisen Schweiz, a leading Swiss retail bank, contracted for Brinks to transport a shipment of banknotes with a gross weight of 53.18 kilos and a value of 1 million. That's a million, not 1,000. 1,945,843 US dollars. At the point where you're shipping currency like paper money and you're measuring it by weight, you are in an entirely different world, right? You are in an entirely different universe than I'm in. 53 kilograms of money. So, and Valcambi, a precious metals refining company based in Switzerland, wanted to transport a shipment of 400 kilos of gold with a value of 13,612,000 francs. They both contracted for Brinks to provide security and logistics services for the banknote shipments and the gold shipment, to indemnify Raiffeisen and Valcambi for any associated losses. This is the big reason why Brinks is suing, because Brinks says, listen, we are so confident that we will get your 53 kilos of money, of banknotes, and 400 kilograms of gold to its destination, that if it doesn't make it, we'll pay you. Now, Brinks is going to be paying this out of their insurance, but I can tell you, if Brinks's insurance, because Brinks, I'm sure, insures its things. If Brinks if their insurance goes up a little bit, just a little wee bit, that costs them hojillions of dollars, like so much money, because, yeah. Now, one thing I will take note of here, you see that the value is 13,612 here. And at the lawsuit, it's 13,612. I kind of think that's interesting. They are asking for the precise value in terms of what I'm sure Brinks has already paid this out, right? I'm sure that they've already paid this money out. But it's interesting because if Brinks personally lost the gold, I might, wait for the price of gold to maybe go up and then file the suit when you think gold has gone up as much as it can, and then claim the value of that much gold on that particular day that you filed. So, but yeah, Brinks is out all of this money right now, or at least Brinks' insurance. So they're going to ship it from Zurich to Toronto with a Air Canada Secure. And they've got a waybill. So the waybill is just basically to say like who's shipping it and where it's going. Special supervision is requested, valuable cargo. And the gold waybill identified Brinks as the shipper and the Toronto Dominion Bank as the consignee. It described the cargo as gold bars with a gross weight of 400 kilos. And I'm just going to say somebody planned this heist, because stealing 400 kilos of anything is difficult, right? You gotta plan this out. You gotta, like, how do you steal 400 kilos out of somewhere? Certainly not a casual thing. Like, if I was a security guard and, I'm just like, you get tempted by crime, you'd probably you might steal 1 gold bar or maybe 2 gold bars. But not like 400 kilos. That's a lot to steal, right? And then you got to ask, how do you get rid of that gold? Like, this is, yeah. And this is a good question. Wouldn't it make more sense to mark the boxes dog excrement samples? No, you can't actually mislabel the boxes. So Brinks books the shipments, so they book it all. They're good to go. Air Canada confirms receipt and acceptance of the shipment, i.e., Air Canada takes control of the shipments at this point. And then the shipments are stolen. So the shipments landed in Toronto at 1556, and they went to the Air Canada bonded warehouse at 1750. At approximately 1832, an unidentified individual gained access to Air Canada's cargo storage facilities, and no security protocols or features were in place to monitor, restrict, or otherwise regulate the unidentified individual's access to the facilities. This is effed up if true. Effed up if true. Because I have more, there's more security at the tobacco locker at a Costco than this, right? There's more security at your local gas station has more security to keep you from robbing the place than this describes. This is messed up. Once inside, the unidentified individual presented to Air Canada personnel the copy of an airway bill respecting an unrelated shipment. On receipt of the fraudulent waybill, Air Canada personnel released the shipments to the unidentified individual, following which the unidentified individual absconded with the cargo. So he just shows up with a forged document and is like, hey, I am here for the 400 kilos of gold, please. And they go, sure, here you go. Here you go. Off you pop with the 400 kilos of gold. And they say Air Canada accepted the fraudulent waybill from the unidentified individual without verifying its authenticity in any way. I'm just going to say, if somebody comes up to me, like if I'm entrusted with $20 million worth of gold, I'm checking some IDs, right? I'm checking some verifications there. Had Air Canada made the necessary and appropriate inquiries in the circumstance, the unidentified individual's ability to steal the cargo would have been entirely avoided. Now, they say that they were reckless because despite contracting to provide secured holding areas and special handling, they failed to do that and failed to have appropriate security footage. And they say that their negligence and carelessness included failing to ensure that its cargo storage facilities offer acceptable and sufficient levels of security and protection, failing to offer services specially designed to protect high-value shipments. So like including storing facilities equipped with effective vaults and cages, constant CCTV surveillance, and active human surveillance patrols. Now, those weren't necessarily the reason why this got stolen. Failing to implement sufficient safeguards in its software hardware systems to prevent unauthorized transactions. Failing to ensure that employee credentials are not susceptible to fraud or misuse. Failing to verify the trustworthiness of all personnel, i.e., they think this is an inside job because it would pretty much have to be. Johnny, that is a hilarious comment, and I'm starring it. Failing to ensure that the specific security measures it advertised and marketed were effectively in place. This is a big deal, right? If you say you're going to do something and you charge money to do the thing, you should do the thing, right? So, yeah. As a direct result of Air Canada's failure to comply with the terms, the shipments were stolen. And so they say Air Canada is liable to Brinks for the full value of its shipments. Why does Brinks want this back? Well, Brinks wants it back so that they can pay their insurer back and change this to a $0 claim, right? And then their insurer doesn't jack their rates. That's my suspicion as to why Brinks wants this money back. But if Brinks self-insured this, then of course they want the money back because it's $20 million. Like, that's not couch cushion money. That's not money you just walk away from. That's big money. Now, why are they in federal court? Because things are governed by the Montreal Convention, which is an international treaty incorporated into the laws of Canada by the Carriage of Air Act. It is also in place in Switzerland and in Canada. It applies to international carriage of persons, baggage, or cargo performed by aircraft for reward. So basically, this is the treaty between different countries that says we're going to hold airlines to some sort of standard of things, right? So the Montreal Convention applies to the facts of the case. The shipments took place after the convention was signed, and that the place of departure and the place of destination are within the territories of two state parties. That sounds right to me. In the carriage of cargo, the liability of the carrier in the case of destruction, loss, or delay is limited to a sum of 17 special drawing rights per kilogram, unless the consignor has made, at the time when the package was handed over to the carrier, a special declaration of interest in delivery at destination and has paid a supplementary sum if the case so requires. So, what is a special drawing right worth right now? Special drawing rights are not worth a whole lot. They're an artificial currency. And I'm just trying to see what they actually go for right now. Since 2015, a special drawing right is limited or is determined as looks like $0.50. So 17, so times 0.058. So I'm just doing some math here. Limited to about $10 a kilogram, $10 US a kilogram is basically what that comes down to. So you better believe that when the when Air Canada opposes this, they're like 100%. I predict that Air Canada is going to say they're limited to the 22 special drawing rights per kilogram or the 17 special drawing rights per kilogram, which basically means $10 per kilogram. Now, I don't know if you have checked the value of gold, but the value of gold is substantially more. In fact, we can do this napkin math here in the sense of if they're getting about $10 per kilogram for 400 kilograms of gold, that would be $4,000 that Brinks would be entitled to. Obviously, Brinks would be unhappy with a win of $4,000. And if I was Air Canada, like if I'm sued for $20 million and I get that claim down to $4,000, I'm feeling pretty happy, right? I'm feeling pretty happy. Oh, I see somebody says it's more than $19. All right, well, whichever. It's not a whole lot of money. as compared to the price of gold. So what they're noting is that they have said we have a special declaration of interest in delivery at destination, i.e., this is high value cargo, and they paid a supplementary sum. That's why they told us ahead of time we paid more for this service, is to get them kicked out of, Article 22.3 and into you pay the actual value of it. In the event that the preconditions set out in Article 22.3 are satisfied, then the carrier will be liable to pay a sum not exceeding the declared sum unless it proves that the sum is greater than the consignor's actual interest in delivery at destination. I.e., what does this mean? It means that if you escape that 22.3, restrictions, then they have to pay what you declared the value to be. So if you declare the value to be $1, you get $1. Don't do that. But if you declared the value of, like, if they said that this $20 million in gold was actually worth $600 million, then Air Canada could be like, no, it's only 400 kilos of gold. This is what it's worth. It's worth 20 million. That's all you get, right? So that's what that means. It's the lesser of those two, right? They say that if the convention recovering limits were to apply to Brinks, which for the reasons set out below, they would not, Brinks would only be able to recover approximately $1,540.39 for the banknote shipments and $11,000 for the gold shipment, which is less than 1% of the actual value. Can you imagine paying, or like, could you imagine getting banknotes at $20 a kilo? At that point, Air Canada would have every incentive to just keep the money, So Montreal Convention doesn't limit it. So, yep. Special declaration of value. They provided a declaration. So 400 kilos of gold and 50 kilograms of banknotes classified as high value. And they disclosed the value of it. So that's critical to that. They say there can be no question that Air Canada had actual knowledge of the high value amounts. The supplementary sum, they paid additional money, right? They paid additional amounts. That's critical. As noted, Air Canada's webpage says that they assess a special fee for this, so that seems to qualify. So they say their liability is not limited, and they're liable for the full amount. And Brinks proposes that this action be tried in Toronto, Ontario. I actually think that this is a really, really well-written statement of claim. And what I mean by that is that a lot of statements of claim are overwrought and are they make these like big, huge claim, like big, huge, Air Canada was like, these villains. And Brinks doesn't need to do that. Brinks is in the luxury position of being able to come in and basically just nail Air Canada with things that I'm pretty sure that they can prove, that I'm pretty sure that they can like establish. Like the whole thing of we paid you more. I don't think that's even going to be like, that may not be in dispute, but this is going to be a real interesting case. And ultimately, I'm wondering who stole this money and where it went. What happened to this money is going to be a real interesting question. And if you happen to be in the Toronto area and somebody comes up to you and is like, want to buy a cheap gold bar? Maybe don't buy it. So, all right. And somebody says Air Canada should have just paid this off to avoid the publicity. It's real hard to pay off $20 million. I don't think they're going to want to, pay that off in a big way. All right, let's look at some super chats here. Equality says, I miss this so much. Your chat is funny AF. Haha. Well, thank you so much. CG, thank you so much for the super chat there. Much appreciated. JR, speaking of jury tampering, what are your thoughts on the Mindy Tran case in Kelowna where the accused was acquitted and ran off with a jury? I will have to I'll have to look into that, but that sounds messed up. Reminds me of the JFK Lufthansa heist. See the movie Goodfellas? I haven't watched Goodfellas in forever, and now I want to again. And Johnny Osprey says, "This is the lockpicking lawyer, and today I'm at the Toronto airport." Fun fact, I have met the lockpicking lawyer. He's a very nice guy. Don't ask me what he looks like or his name or anything like that, because none of your business. But he's a very pleasant individual. He is exactly as pleasant as you'd think. And it was funny because I walked up to him, like I met him at an event, and I sort of introduced myself, and he's like, "Hi, and I was like, "I know who you are. I know who you are," because his voice is so distinctive. It's a 100% distinctive voice, and I was like, "I know exactly who you are." So, yeah. Now I'm probably going to wrap this up fairly shortly here. I'm in competition, I think, with both Rob and Emily, which means that not a whole lot of people here, but I am going to talk about I am going to talk a little bit about the fundraiser that we're doing here. The fundraiser, which is coming up on November 4th. So November 4th, I am going to be going 24 hours for charity. So I am just going to be, I'm going to be gaming. I'm going to be hanging out with friends. I'm going to be online for 24 hours, and we're raising money for sick kids at the Stollery Children's Hospital. So let's talk about some of the things that are at auction, because I am running an auction. You can bid on this rock. Now you might say, "Isn't this a rock from your backyard?" And that is correct. It is a rock from my backyard. It also appeared in a video where I joked about selling the rock. And people sent me emails saying that they wanted to buy the rock. So we're going to auction the rock. And I will make up a certificate of authenticity with the rock for the rock that appeared on a video. And you can own this lovely rock that came from my backyard. I don't know why you'd want to, but you can own this rock. So for some reason, the rock has had a lot of interest. You can also own this, which has appeared in my Get Ready With Me video. And so the Get Ready With Me, and yes, I am starting at midnight. So we're going to start at midnight for that. So the rock is unblemished, but I will include a certificate of authenticity with it. So what this is for is you put a bottle of hot sauce in it, and then it goes under the barrel of a gun. Do not fire the gun when this is in place, because I don't think glass near a firing gun is a good idea. But I will send this to the winner with a bottle of my hot sauce if it's getting sent to Canada. I cannot send my hot sauce to the US yet. If you win this and you are in the US, you can ask for a different place for the hot sauce to go. But I will put the hot sauce, so you'll get this as a thing. I will probably do some hot sauce, bids as well. I also have my leather journal that I'll send off. And I'm just going to note here that that is in the garage right now, so I can't show you it right now. Philip Martin says, "Which of your hot sauces? Whichever one you prefer. If you want the hotter, you can get the hotter. If you want the milder, you can get the milder." Will I send the hot sauce to the Stollery? The kids are already in the hospital, so yeah. Yeah. Let's not do that, but yeah, that is sort of what we're looking at here. Now, I'm going to have a bunch of other things for auction. A bunch of people have donated things. I'm going to try to carve the egg I got an ostrich egg. The ostrich egg I kind of forgot about in my fridge, so I don't really want to eat it now. But I am going to try to carve that ostrich egg into some sort of pattern, and hopefully I could sell that. So you can buy a carved ostrich egg. That's kind of what we're looking for there. Rob is donating some pens. What is it? Kristen M96 is donating a custom robot. So if you see the robots in the back of Rob's stream, the robot jury, then that's available. You can get one of those for yourself. KVP Studios, or KVP Studios, I think it is also has also donated a painting. There's going to be a bunch of stuff on auction. I'm also going to do some giveaways just to for if you're in the chat, I'll give some stuff away, and that's kind of the game plan. So yeah, at this point, I think I will wrap things up. There's a couple of late things here. Box SB, they're November 1st per tracking. Also, I think one of the sauces has Pepper X in it. Hopefully there before Saturday. Ooh. Nicholas Staros says banana on the pizza. Nobody in Canada offers banana on the pizzas. Like, you just can't get it. So can you ship the hot sauce to outside of Canada and the US? I don't know. I don't know which one there. So I don't know like which rules are there. So, and John Rass is asking, is your silver coin contest still going? It is. Those are still in my safe. And yeah. Carolyn Lower says, what is the starting bid on the rock? $1. We'll start the bidding at $1. Hopefully we'll start the bidding at $10 including shipping, because I got to ship this rock. So, all right. I am going to wrap this up here. As I mentioned, I got a trial tomorrow. I got some other stuff. I got to prepare for my stream too. I still got some technical issues I haven't figured out yet. So, all right, let's roll this and see you guys next time.